Hey everyone, Harry here to talk about Special Counsel Jack Smith's 67-page filing in the Court of Appeals for the District of Columbia, urging that court to reinstate Judge Tanya Chutkan's gag order. So remember, Chutkan imposes the gag order after a series of incendiary statements. Trump then pushes back and says, I think there's a First Amendment problem with the word target. And while Chutkan considers that motion over 4.5 days, she lifts the gag order temporarily. That matters because, as Smith points out in the brief, during that time, he goes on, an absolute fusillade of nasty Truth Social messages, almost 200 of them in the 4.5 days. Chutkan then considers and reimposes the order, keeps the language as was, says no First Amendment problem. All right, at that point, Trump appeals to the District of Columbia Court of Appeals, which sets a pretty quick schedule and says that it will hear argument on it on the 20th. Next Monday, I think that is. And here is the brief for that argument that Jack Smith files. He points out, by the way, that in about the same amount of time since the Court of Appeals gave an administrative stay. I've mentioned this before, but just to repeat, the Court of Appeals, when it takes the case, imposes an administrative stay. So also, again, lifts the gag order. Not as might be an indication we're going to rule for Trump, but just what in that court in its sort of special practice calls an administrative stay, just to, completely even the playing field, to give it a chance to get up to speed. In that time since then, Trump has gone, even for him, really, really, really over the top. He savages Jack Smith, calls him again every name in the book, and then what has to strike any judge in the system, any person, he savages Jack Smith's family. He says that Jack Smith is prejudiced against him on a scale of 1 out of 10, 10, and his wife and child, 15. It's nauseating and really dangerous. I'm sure if they didn't have it before, his wife and daughter now have to have special protection. It's a virtual call to arms for his terrorist followers. That is to say that, his craziest, and they're certainly out there. We already know that when he first savaged Judge Chutkan, there were calls, including from someone who said they were going to come kill her. She's apparently received, hundreds of racist and nasty calls. So now Trump goes after Smith's family by any measure that is repulsive and really, really dangerous. All right. So anyway, that happened in these days. It would have been, I think, a grounding for Smith to come in right away and say, reimpose that gag order, take the administrative stay off. They don't do that. If you look at headlines quickly, it suggests maybe they are, but they're not. They're just saying, reinstate it when you hear it on the 20th. And I don't know if the vitriol and nasty inflammatory rhetoric he uses wouldn't justify or wouldn't push them to do it. I'm not sure if anything would. So I think they're focused now on going to Monday and making the argument on the merits. Now, with this kind of quick schedule, and just I think the Court of Appeals can nevertheless be it can be anticipated that they're reading the newspapers like anyone else and seeing this really vile display by Trump that would violate any gag order in the book. And I wouldn't be surprised if shortly after the argument on Monday, an opinion affirming Judge Chutkan comes down which is to say, I wouldn't be surprised, and it happens in cases like this, if somebody already is writing that opinion on the panel, which is a pretty strong panel for the government and pretty weak one for Trump. All right, let's now go to the argument that Smith says should justify them in affirming Chutkan's first argument. We have Trump basically came in and tried to conceptualize the gag order as a prior restraint on speech, which requires basically the highest level of scrutiny in the whole federal system. For you to tell, you know, this is a little like the Pentagon Papers, where the court refused to do it, right? Going and trying to keep a paper from publishing a true report. Man, you really have to make a very, very, very strong showing, almost impossible. And that's what he's trying to say. Look, in response, before I have violated the order, of course, the predicate's been laid, 200 times with the absolutely beyond the pale stuff he said. You've done this, and you have to, Judge Chutkan, have a very, very, very high threshold. And Jack Smith says, and I think rightly, and this is what we should expect the Court of Appeals to do, they're just whiffing here, Court of Appeals. It's a category mistake, as I've called it. They're making it seem like it's a prior restraint on speech. It's not. It's not about the content even of the speech. It's a whole different government interest here. I mean, it's about the content in the sense that he's threatening people, but what it is about is protecting witnesses. And they say, by the way, target is clear enough. And if there's any doubt, there's going to be an adjudication with briefing on either side before she finds that he's violated the gag order. So there'll be plenty of time then to really zero in on how whether he's targeted clearly enough. But this isn't about a prior restraint on speech. This is about protecting, safeguarding the integrity of trials, safeguarding witnesses, not polluting the jury pool. And to that end, they start in a very different place from Trump. They start with the promulgation of the rule by the Judicial Council that permits gag orders to be imposed in trials and gives the reason for them. And so what's really at issue is that rule that's been applied across the board fair and constitutional. And it's been many times affirmed. Basically, if Trump were right, every single time a gag order were imposed, they'd have to jump through these 25 hoops, and that's not what they do. They look to this rule that's been promulgated. It is constitutional. What does it say? It protects, as I've said, the witnesses, but it says. And Jack Smith says now to the Court of Appeals, there's got to be substantial evidence, but not substantial evidence of what? Of the risks that led to the promulgation of the rule. Risks of danger to witnesses, risks of polluting of the process, etc. And substantial evidence, we've got the strongest evidence I've ever seen. I've said this again and again. I think most commentators agree with me. If he were anybody but Trump, he would long since have had his conditions of release revoked. Remember, he's on release now by grace of the court that says, we won't put you in pending trial, but you've got to comply with these things. And this would be one of them. He's been so incorrigible, but it's this position that courts are sort of tied in knots, not wanting to put the putative nominee of a major party for president in jail. But, and I've said this before too, and I'll close with it, it really is up to Trump. He is shown again and again almost a desire to violate the rules for whatever kind of political points he thinks he gets from it, of being a rebel and a martyr and a revolutionary against the deep state or whatever. This gag order needs to be reimposed. I think it will be reimposed. Will he violate and violate it flagrantly? He might well. That would be the evidence of the last month. And that will move pretty quickly then at this point to Chutkan saying something like, one more time, I'm putting you in jail. That's all I can do. And I'm revoking your release. And we'll see if he has a broader political strategy of some kind of martyrdom of going in for his supporters, and that somehow suits his basic sole legal strategy, which is the political strategy of trying to become elected for president. The system at some point just can't continue to indulge him, and will have to put him in. He's being a clear and present danger. Remember, he also retweeted an arrest, a poster saying, let's make a citizen's arrest of the AG and the judge in the New York fraud case. Totally illegal, totally an incitement to danger for them. The system, if he forces it to, will have to put their foot down. And I think it's building to that point one way or another soon. We'll see a gag order, and we'll see if it brings him to heel or doesn't. And if it doesn't, they have to use the tools they have. And that means yanking his release. Okay, so big filing, basically saying, and this is the thing to look for, you don't need a law degree for it, that Trump's just got a mistaken analytical framework. This is just about the validity of gag orders under a general rule in the first place. And I think you'll look for the Court of Appeals to agree, and in fairly short order. And then the drama intensifies, and we really see what Trump wants to do. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.